Good afternoon, ladies and gentlemen. I'm Professor Vann, and I'm a member of the faculty at the law school. First of all, I want to apologize to you for not being in more conventional business dress. If I had known that I was going to do this, if I had had more than 10 minutes advance notice, I assure you that I would have cleaned up my act. I assure you would do my closest respect as intended and honest take. Before I introduce Professor Vann, I will say a few things about the Norman Sugarman lectureship. Mr. Norman A. Sugarman was a graduate of this law school, a distinguished graduate of this law school, who early in his career went to Washington, D.C. and worked for the Internal Revenue Service. There he had a meteoric career, and by the time he was through with the service, he had been the chief of the exempt organizations branch and also assistant commissioner. When he left the Internal Revenue Service, he went to work at the Washington office of the firm Baker & Hauser, one of Cleveland's leading law firms. Mr. Sugarman was devoted to this school. He was also devoted to the study of taxation. And he endowed this lectureship, the Sugarman lectureship, with the idea that he would bring to the school, for the benefit of the students and the faculty, distinguished people in the tax field from government, from academia, and also from the practice of law. As a result, over the years, we have had as Sugarman lecturers a commissioner of the Internal Revenue. We have had a couple of chief counsels of the Internal Revenue Service. We have had distinguished practitioners and a couple of judges of the tax court, Judge Shabbat, Judge Renato Gay, also happened to be a law school classmate of mine. We have also had one of our own graduates, chief counsel of the Internal Revenue Service, Don Corp, who is now serving in that capacity. Our distinguished academics have been people like Professor Martin Churlstein, originally from the Yale Law School, and now at Columbia, as well as Professor William Andrews of the Harvard Law School. I'm sure that you probably know. Well, this year's Sugarman lecturer is Professor Richard J. Vann. Professor Vann is the Challis Professor of Law at the University of Sydney in Australia. He is also currently the William K. Jacobs Visiting Professor at the Harvard Law School. Professor Vann specializes in corporate and international taxation. He has taught at the University of Sydney for over 20 years, and he is currently a visiting professor at Harvard Law School, a member of the Hauser Local Law Faculty at New York University. It is my pleasure, on behalf of Case Western Reserve Law School, to present to you Professor Richard J. Vann.
Thank you. I just have to get my notes back. It's a pleasure to be here. I haven't come all the way from Australia, just from Boston, but it's my first trip to Cleveland. Too short, I'm afraid, but I'm enjoying the hospitality here. The title, Domestic and International Fringe Benefits, How and When to Tax a Free Lunch. It would be much better to do the talk at lunch, which I did a short version of for the staff. It's going to cover two main topics. One an Australian specialty perhaps, and that is taxing fringe benefits to the employer, and just exploring that idea and asking whether it's a good idea, as I hope to show it has some relevance to what is proposed in the US, not in the fringe benefits area, but in other areas for reform. And then to move on to something which has a personal interest to me this year, seeing as I'm having to file tax returns in Massachusetts with the IRS and also in Australia, and that's the international treatment of fringe benefits and employees more generally, and in particular has the globalisation problem that we experience in many areas of taxation, the same in the employment context, and is the system working? So I suppose start with a simple question which many students do very early on in their tax course, and that's why you like tax fringe benefits. I'm not going to say much about it. It's fairly obvious that fringe benefits are just another form of remuneration if you don't tax them. Same way as you do salaries, then that will cause
lot of activity by taxpayers to receive fringe benefits, and also will have unfairness implications. It's more the cons that I'm interested in, because around the world it's true to say that fringe benefits are taxed, but they're not taxed anywhere near as fully as you would tax employment income. And it's because of these cons that's the case. One of them is the technical complexity of taxing fringe benefits. Valuation is an obvious issue, which is always a problem when you haven't got cash, but you've got something in substitution for cash. Another one is the separation of benefits from conditions of employment. In Canada, they think travelling first class on an airline is a fringe benefit, even though you're travelling on business, whereas in the US you don't think that's a fringe benefit. So there are lots of different lines that are drawn there in different countries. And then thirdly, and the main justification for the fringe benefits tax on the employer, is the allocation problem. We actually did have a free lunch today, and if it was going to be taxed, you've got the problem of very small benefits being conferred on a large number of people over the year, but trying to track them through to individual tax returns would be a nightmare. And so allocation is solved if you just tax the employer in one lump, and that's a major reason why some countries have adopted it. It's also true to say, and this particularly applies to the US, that a lot of social policy is implemented via the treatment of fringe benefits. So your health care policies, your childcare policies and your pension policies are significantly influenced by the way the tax system treats those forms of fringe benefits. More so than in many other countries where healthcare may be free or where childcare may be provided more generously by the government. But it's true in all countries, particularly in the pension area, that a lot of the benefits, the tax benefits provided in the fringe benefits area are designed to achieve social policy objectives. And then the third con is the problem that if you haven't historically taxed them, then wage bargaining will have taken account of that fact. That people will have bargained their wages on the basis that, well, I'm getting this which is not taxed, the employer will offer me less of it than if it were being taxed. And that also means that you get a political and transition issue when you want to change the rules. You might agree that taxing fringe benefits is fine in theory, but if you haven't been doing it and you want to do it in practice, you get political and transitional issues. So that brings me to the question of how to tax fringe benefits. And the obvious way is directly on the employee, which is how most countries do it most of the time. You can find in nearly all countries elements in the system where fringe benefits are being taxed indirectly. The amount of those elements vary from country to country. The indirect ways of taxing fringe benefits, the most obvious is in denying deductions to the employer. So the employer pays a higher, usually corporate tax rate, a high amount of corporate tax, which is effectively a proxy for tax on the employee in relation to the benefit. This, in many countries, applies to entertainment, whether on employees or third parties. That deductions are denied as a way of getting at the benefit that the employee is receiving. The excise tax, what I call it, just a tax that's levied on the employer, like the Social Security tax, the portion of that that's levied on the employer in the US, is just a way of taxing the employee indirectly. It's not intended to, if the tax ends up on the employer, it is intended that the employee will bear the tax through the wage negotiation process. And the reasons for taxing indirectly are precisely the kinds of matters that I mentioned a moment ago when talking about the cons of taxing fringe benefits. If you've got a situation where you're not currently taxing fringe benefits and you want to tax them, governments have found it easier to put the pain initially on the employer and then allow the wage bargaining process to work that through to the employee as the fringe benefits tax is taken account of in future negotiations, wage negotiations. That also solves to some extent the transitional issue. Of course, the employer is now bearing a transitional tax which they may not like,
but that creates an incentive for them to bargain with their employees so that the tax will be shifted over time to the employees. And that's what's happened in Australia. When you bargain with an employer, they say, well, this is the amount I want to give you. Much like in the US, there's then a menu of benefits that you can take. But one of the major items in that package is the fringe benefits tax, which goes into the overall package. The other reason that's put forward, apart from the allocation one that I mentioned, is compliance and administration. I think that can be overstated because employment taxes are run through employers anyway, so it's not going to make much of a difference to compliance and administration. It just means in the Australian case, for example, the employee does not have to include the amount on their tax return and run it through the tax return process. The tax on the employer is the final tax. So if we turn to the indirect methods in a little more detail and look at how they work or don't work, in each of them you've got a common problem that, unlike when the employee is taxed, you can tax the fringe benefit at the correct tax rate, the employee's marginal tax rate. If you're going to tax the employer as a proxy, it's impossible to get the right rate. So what countries tend to do is use either the corporate rate. Unlike the US, in most countries, the corporate rate is below the top maximum individual rate. So that means there is some benefit in giving fringe benefits in many cases. And if you've got them the same, then you're going to have an effect, as in the US, it will be at the top rate. So 35%, just talking federally. I understand when you get to the states, things may change a little. But federally, the rates align. If you deny a deduction, it's like taxing the employee at the top marginal rate. The problem is tax-exempt employers. If you're going to, the most obvious problem, if you're going to tax employees by taxing the employer, and the employer is tax-exempt, then it doesn't do any good to deny deductions. The same applies to a lesser degree if the employer is in tax loss. You just don't get the tax because of the exempt or loss status of the employer. And in a sense, in Australia, that's one reason why we went the next step to the excise tax, because then you do collect the tax from the employer. But there's also a more subtle problem with the tax, where you've got a taxable employer. Some of you may recall that President Bush's original proposal in 2003 for taxing dividends was that dividends would be exempt to the extent that the corporation had paid corporate tax. And there would be an account kept by the corporation, and dividends paid out of that account effectively would be tax-free. And other dividends would be taxable in the ordinary way. Now, that went away and the 15% flat rate came in its place, but the 15% rate is not here forever, or at least on the books it's not here forever. And this idea of only giving relief to shareholders on dividends to the extent the corporations pay tax has a fairly long history as a proposal in the US, going back to a 1991 Treasury study of the issue. So it's possible, and this applies in many other countries, that dividend relief systems, that is, trying to take account of the tax on the corporation when you're taxing the shareholder, relate to the corporate tax paid. Well, if that's the case, then denying the deduction to the employer misses its mark, because all it does is generate tax benefits for shareholders. The tax paid by the corporation is achieving a tax benefit elsewhere in the system. And so if you use this mechanism, which the US does, if the US ever went to a system where dividend taxation related to corporate tax paid, then you would need to adjust the corporate tax paid to exclude the amount that related to the fringe benefit, if that's how you're trying to tax the fringe benefit. Otherwise, you simply substitute, as I say in one of the brief papers you've got, tax-free dividends for tax reductions. And if the executives hold lots of shares, nothing really has changed. It's the same outcome of effectively no taxation. You also get issues of employee deductions. I'll skip over that here and come to it in relation to the next way of taxing fringe benefits, and that's by an excise tax. That is, you simply tax the employer and the employee excludes the fringe benefit from their return, pays no tax on it. We collect a lot of tax in Australia from this mechanism. So as a revenue-raising device, it's been quite successful. It does raise significant amounts of revenue compared to, obviously, the tax paid by employers on salaries is more, but the fringe benefits tax is a substantial part of the tax on employment income. When you get down to the tax, as I explain in the paper on Hussey and Lubick, and I apologise for the sort of international and Australian bias of the papers, but you can analogise them to the US in a number of areas. The tax, if you're thinking of an equivalence to salary, if you get a $100 salary which is subject to $35 tax, so that you get $65 in your hand, and you substitute a fringe benefit of $65 for that, then the right amount of tax is $35 to levy on the fringe benefit. But if the fringe benefit is measured by its value, then a 35% tax rate on $65 is not going to give you $35 tax. You either have to gross up the benefit for the tax, or you have to gross up the tax rate. And in Australia, where we've had individual tax rates in the 40%, rather than we only have one level of income tax, not several, but the tax rates are in the 40s, the top rates, that means you gross up by a factor of about 80% when you do the calculations. So it's a significant gross up. If we actually did it in the tax rate itself, which would be 46%, would be grossed up by 80%. So it's a significant amount of gross up that occurs and makes the tax look awkward. It makes it look like it's got either a high rate or it's got a very large tax base. And it's just trying to compare salary with the benefit, but it's not a natural thing to do. And I discussed that to some degree in the Hussey and Lubick paper. The tax-exempt employer ceases to be a problem in one sense because you now just tax the tax-exempt employer just like they pay or collect the tax on wages and send it off to the government, so they collect the tax on benefits and send it off to the government. But charities and the like are very political animals, and in Australia they have successfully argued that you're taxing the charity, you're taking money away from good works, you're not really taxing the employees. And we have a number of concessions in the system that effectively allow charities to pay less tax, or the employees of charities to pay less tax on their fringe benefits than you do if you're working in the taxable sector. So although the technical problem goes away with the tax-exempt employer, the technical problem in the deduction area, the political problem doesn't. Whenever you try to touch charities, there's always a political problem under the tax system. Another issue you get is because you're taxing the employer on the fringe benefit and the employee on wages, we still tax the employee on their wages, you have to draw the line between what are wages and what are fringe benefits. Now, initially that may seem to be a fairly simple line to draw, but at least our experience is when you get into a number of kind of cash reimbursements that employees get, it's not clear whether it's appropriate to regard it as part of salary or as a fringe benefit. And we've had quite a lot of case law on the problem of which side of the line do certain kinds of payments fall. The difficulty for the IRS or for our tax office in that kind of scenario is if they pick the wrong taxpayer and lose, it's too late to go back and amend the returns of the correct taxpayer, just because of the statute of limitations having passed by the time the decision is made. So there are a number of issues in that area. And then finally, so far as the reasons for the tax are concerned, what we've discovered is that after all we do need to allocate fringe benefits to employees. And the reason is that a lot of our tax and benefit system depends upon your taxable income. So I've given here a similar example in the US. The earned income tax credit depends on adjusted gross income. Now, if you're not putting fringe benefits into that amount, you get a bias in favour of fringe benefits so that people can get the benefit, the other benefit, the tax credit or whatever it is. In the Australian case, we had employees getting up to 50% of their packages in fringe benefits to keep them below the thresholds where they got the other benefit under the tax system, the credit. We have a similar credit in Australia. We copy lots of stuff from the US. We have something like the earned income tax credit. And we have a lot of our social security system dependent upon the salary or the taxable income of the person receiving benefits. So a few years ago we've turned around and now require employers to allocate not all but most of the benefits back to employees, even though that was given as one of the reasons why this was a good tax. You didn't have to go through this allocation process. And then finally, employee inclusions and deductions. Obviously there's no inclusion if the employer is taxed, the employee is exempt. But what if, say, an interest-free loan, which is used to buy shares, in Australia as in the US, the interest would be deductible to the person making that investment. And what we have to do to make sure that fringe benefits are treated the same as direct taxation of the employee is that we run a whole system of employee deductions through the fringe benefit system as well as through the ordinary taxes. So that if it's an interest-free loan which you use to invest, we don't have a mortgage interest deduction in Australia, I'm sad to say, but we allow other deductions for interest in income-producing investments. If the loan is used for an income-producing investment, then the employer effectively claims a deduction against the amount that was the fringe benefit, so that there is no taxation on the employer. That's complicated, but it's not too complicated. The US has a similar system for reimbursed employee expenses, where you provide documentation to the employer. They do not then put it on your wages form. So the system is like that, but it means you've got a whole separate deduction system having to run under the fringe benefits tax as well as in the ordinary income tax. So is there a moral from this story, or is it just an Australian oddity which you can ignore? Well, there is, and that it applies not just to the excise tax, it applies also to the deduction route. And that taxing indirectly under an income tax is generally not a good idea, because you get a lot of unexpected complications and results, and that's been our experience in Australia. And I think it would be the experience in the US, not if you have a fringe benefits tax, for example, but if you go to a shareholder, a system of taxing shareholders on dividends, which depends on corporate tax paid, you're going to have to go through all the deductions which corporations claim and decide which ones of those should generate tax benefits for shareholders and which not. It's a technical issue that you don't need in the system. It doesn't just apply to fringe benefits, it would apply to fines, it would apply to caps on how much of salary can be deducted, all the things where deductions are denied. You have to decide well, do we really want to deny the deduction, or are we happy for it to generate a tax benefit for shareholders? But more directly in the US case, it's striking how many of the US tax reform proposals, coming from the deepest minds of economists, which we can say in this company are largely lawyers, that they like this mechanism of taxing things indirectly. And so when you look at a lot of the tax reform proposals in the US, they often try to tax someone indirectly by denying a deduction to someone else. One of the examples is the CBIT system which was proposed by Treasury, again in that 1991 report, which was to deny a deduction for interest to corporations, essentially as a means of taxing the recipient of the interest. And whenever you see that feature, then you've got to think through the implications of it. I won't do it here, but when you start to think it through, I think you start to see exactly the same kinds of problems that I've been talking about. What are its implications for the earned income tax credit if you still have such a credit in the reform system? You have to go down the track that we've gone in Australia. If I turn to the international area, this is a case where the US does have to take notice that Australia actually taxes under the fringe benefits tax. Because we have a lot of US citizens working in Australia. They're taxed in the US because they're US citizens. They're being taxed in Australia. And they've got to try and work out how this fringe benefits tax fits in to their tax position in the US. And the answer is it doesn't very well. So before I come to that, just talking a little bit about why it matters. Globalisation has, as for many other areas, also for employees, is starting to have a big impact on taxation. It's now very common for highly skilled people to move around the world during their working career. It's not just senior executives in corporations. There's a lot of IT people. It's a lot of people where skills are in short supply, like nursing and teaching in some countries. We get nurses from the US and the UK. So you get a lot of people moving around the world, much more so than was the case in the past. And even more generally, say within Europe, it's now the case that if you live in one European country, you have a right to work in another European country. They have freedom of movement of labour within the European Union. But they don't have a European Union tax system. They still have national tax systems, and you have to work out and file your return in your residence and in the country where you're working to try and solve your tax problem. The arguments for this are the same ones as for free trade and free movement of capital. Whether you buy them or not is another matter. But it's the same kind of arguments which are made amongst policymakers that we need more of this, not less of it. We need more freedom of movement of labour. The traditional barrier immigration laws, you're having a big immigration debate in the US about the porous borders, but you've got lots of people like me coming to the US and working here. So there are a lot of people in the US who are foreigners. I'm still a tax resident in Australia. And likewise, even more so, you've got a lot of US citizens out around the world who are working in other countries. The structure of international taxation for employees, I won't go through this in any detail, but essentially it's not uncommon for two countries to end up taxing the same employment income, either on a citizenship basis in the case of the US or on a residence basis in the case of most other countries, and then in the country where you work on a source basis. We have mechanisms that are designed to prevent double taxation, but what we're finding in this area in particular is that those mechanisms don't work all that well. They in fact work better for corporations and business income and investment income than they work for employees, and I'll go through why that's so. And the other issue which this raises is the compliance and administration one. It is a very big issue. If I go back to Australia and hire someone to file my US tax returns, I'm going to pay some thousands of dollars for that. And companies typically pay large amounts for their employees to have their tax returns filed in various countries. So there are very big costs involved once you have to file in more than one country. I'm going to try and do it myself manually without TurboTax, but I may give up halfway through. Okay, so what are the international problems that we get in the fringe benefits area? Well, firstly, this problem of working conditions is more of a difficulty in the international area than it is in the purely domestic area. If you're working in Cleveland and your employer pays for your child's school fees to go to a private school, then everyone's going to pretty well say that's a fringe benefit, subject to any benefits, tax benefits you have for education expenses. It should be taxed. There's not going to be much disagreement on that. But if an American comes to Australia, we have public schools, good public schools, but they don't prepare you for college in the US. We don't have standard admission tests. We don't prepare people for admissions tests. But we do have private American schools. So what American expatriates will do in Australia is send their children off, if they're living with them in Australia, to the American school, and their employer will pay a fairly large sum for the privilege, because the employer will finance that as a fringe benefit. Well, the question is that really a fringe benefit? They're getting in Australia what they can get for free back home. It's just because of the local circumstances that you have to pay for it. So you can go through a lot of benefits and start thinking about them. Health, education, travel to and from your home country, accommodation. There are lots of things which you might say, if it was just done locally, is obviously a fringe benefit. When you look at it internationally, you think, well, probably it's not a fringe benefit. The difficulty is that most countries so far don't recognise that kind of argument. So you just say, well, you're here, you're getting your school fees paid. If someone else who works here and lives here is getting their school fees paid, we're going to tax them the same. So that you don't get much recognition, which means that the tax costs of expatriation are quite high. A lot of things are provided more or less of necessity, which end up being taxed as fringe benefits. Secondly, there'll often be a change of residence involved. Now, for US citizens, it's a little harder to lose your US citizenship, or at least people are reluctant to lose their US citizenship. But if I stayed here for another year, I would be treated in Australia as no longer a resident there. And then if I go back in a year or two's time, I would be treated as having become a resident again. Changes of residence, it varies from country to country, but they are often tax triggers. They trigger various tax consequences. And that means for a lot of people who work as expatriates, they often have two changes of residence in short periods of time, which trigger various tax consequences. A typical one may be, which I'll come to a little more, is a pension plan. You may find that when the US employee comes to Australia, they stay in their US pension plan, and lo and behold, Australia starts taxing them on the contributions to that plan under the fringe benefits tax, because it's not one of our recognised plans. It may be recognised in the US, it's not recognised in Australia, and we have a requirement that once you become resident in Australia, you have to contribute to Australian plans. So you're now contributing to an Australian plan, and lo and behold, the US is saying, you're a US citizen, it's got a contribution going into a plan that we don't recognise, we're going to tax you. So these changes of residence, that the pension's more complicated than that, but you often find that kind of outcome with pension plans, that people are having to contribute to two pension plans and getting taxed in two countries, one on each of the plans, and because you're not being taxed in the other, you just end up being double taxed effectively. So the changes of residence are a problem. The third main problem is that because of the varying histories of fringe benefits taxation in countries, this is one of the areas where tax systems diverge the most. So most other countries tax health benefits provided by employers. In the US, because of the way the health system is structured, they're not taxed. So when you have a US employer who's still paying into a US health plan for a US citizen working in Australia, you find that Australia's going to turn around and tax that benefit again, just because we don't exclude it and the US does. The exclusions and the inclusions are quite different. The timing is quite different. This is particularly true of employee stock option plans. You can tax a grant of the option, an exercise of the option, or on sale of the shares. Countries tax all over the place, and many of them give employees elections as to when you tax. And it's very difficult to line those taxing points up to get the international system to work properly, particularly if in the meantime there's a change of residence. So you may go to one country which taxes on grant, and they grab you because you're resident there at that time. You're in another country at exercise, and they say, we tax on exercise, they grab you at exercise. And then you go to a third country which taxes on sale, and they grab you at taxation on sale. And you've got to try and work out, how do we ensure there's only one level of taxation on what is effectively one benefit. There are also character problems. The stock options, some countries tax them as remuneration, others tax them as capital gains. So you have difficulties often of lining up the character of the income when different countries have different rates on different kinds of income. And then finally, and this applies particularly to pension plans, ring fencing of tax benefits. The US, like many countries, gives significant tax benefits to pension plans. They don't want you to take all those tax benefits and then decamp to Australia and get the pensions untaxed in the US. They want to claw back the benefits at that stage when you start to get distribution, to not claw them back, but at least to collect the tax that was anticipated when you made the contribution to that plan. For that reason, typically pension plans are very strongly ring-fenced. That is, there are very special rules which do not travel very well across borders. They work fine domestically. Once you go across borders, you're jumping often across, back and forth across the ring that's fencing the benefits in. And that can have significant tax complications. So if, for instance, you take your money out of the US plan, that may get taxed in a penal way because you've taken it out early. And then you put it into an Australian plan, and we have the tax money going into plans for foreigners. So we would then collect tax on that same payment, where you're just trying to maintain the status quo. In fact, you may have triggered a double tax on that payment, or transfer from one pension fund. And then finally, the international system generally assumes that fringe benefits are taxed to employees. Now that means that the rules don't work very well if you're taxing fringe benefits directly. As I've said, most countries tax some benefits indirectly, often by the denial of a deduction. Now if you do that, you get very funny results. So suppose a US person is in Australia working for a US company, an Australian subsidiary of a US company. In Australia, we will deny the deduction for entertainment, much as you do in the US, except we do 100% and not 50%. And then the corporation pays tax on that benefit. When the subsidiary pays a dividend back to the US, that will show up as a foreign tax credit for the parent corporation. So it means that Australia's denial of the deduction has simply generated a tax benefit in the US, and the corporation, with any luck, will fall back to denial of the deduction because it's getting a credit in the US. It's the same point I made about if the treatment of dividends depends on corporate tax paid domestically, then you've got a problem with this rule. Well, you do get it automatically internationally because many countries use foreign tax credits, including indirect foreign tax credits for dividends from subsidiaries, and when you get that dividend and the credit is given by the country of the parent, it effectively cancels out the taxation of the fringe benefit on the employee, which doesn't seem a very sensible outcome. Alternatively, if you have a fringe benefits tax, so assume that the American company, that the American employee in Australia doesn't entertain them but pays school fees. and we tax the school fees under our fringe benefits tax. We tax the employer on those school fees. That means the employee cannot claim a foreign tax credit in the US because the employee has not paid the tax. So in that case, the system just miscarries entirely. We tax the benefit to the employer. The US taxes the benefit to the employer. I'm assuming the employee is above the threshold where you tax US expatriates, which most executives will certainly be. Then you just end up with unrelieved double taxation, and the system just does not fit together. Okay, well, what are the possible solutions to this? They're fairly obvious in a number of cases. One is simply to recognise that working conditions means different things for expatriates. That is starting to happen around the world. Countries are starting to come alive to this issue, and they're starting to think we've got to create special rules for these people because they are different. Their positions are different from local tax. What countries are also doing, and this has been particularly noteworthy in the last 4 or 5 years, is that countries are trying to ease expatriates into their tax system, not just sort of turn the system on or off with taxation of residence or taxation on the source basis, but to bring them in gradually. So they may say, even though you become a resident of the country, we're only going to tax you on your employment income. We're not going to tax you on your investment income back in your home country. We'll leave that country to tax that income. So you can find a number of these, and I've listed some of them here, including special rules for pension funds. The US has been active because the US has got sort of one of these funny things. The US creates the problem through citizenship taxation, and now is running around the world trying to fix a lot of the problem, particularly in the pension area, by negotiating special treaty rules to deal with pensions, to make sure you don't get these mismatches and double taxation. The problem with these rules is that they're often dependent upon the other country taxing, and it may turn out the other country is not taxing for a variety of reasons. So that instead of now having double taxation, we end up with double non-taxation under these regimes. It's not the intended outcome, but it's very hard for one country to change its rules to fit all foreign taxpayers. And you end up with some of the benefits not being taxed at all, which is not, in many cases, the intention. In some cases it is the intention, but in most cases it's not. Okay, what about bilateral or multilateral solutions? These are currently being attempted. They're not mentioned in the papers because they've occurred since then. So the OECD in 2005 has come out with a report and changes to some of the material they produce on treaties, which effectively try to deal with the employee stock option scenario. So they tell you when it changes from remuneration to capital gain. And the US, along with most countries, is going along with these rules. They tell you how to deal with timing problems. In theory, the rules work, but in practice, particularly if you've got a large corporation, employees distributed everywhere, it's still very hard to run stock option plans effectively. A lot of companies, particularly for the foreign employees, do swap over to phantom kinds of schemes because they can't run real stock options, even with the OECD attempt to deal with it. Likewise, there are a lot of new treaty rules appearing. If you look at recent treaties of the US, but also in many other countries, you'll see rules in them which didn't exist 5 or 10 years ago, dealing specifically with employees. Pension plans. The US has been a very big mover, as I've already mentioned, in trying to fix the pension plan problems. And there are provisions in the US model now and in many US treaties that deal or seek to deal with pension plans to get the system to work. The problems of change of residence and the taxes that go with that. If you look at the Australia-US Protocol of 2001, you'll see there are a number of rules in there which are trying to prevent the change of residence giving rise to double taxation in the ways that I've explained previously. And even some treaties are now dealing with fringe benefits taxes, not any US treaties that I'm aware of, but there are a number of treaties that other countries are entering into. Australia, of course, has an interest in this, and a number of our treaties have these provisions. But other countries are also entering into similar provisions to deal with the problem of different ways of taxing fringe benefits. But none of these really solve the compliance and administration problems. If you're going to do that, then it seems to me you need a different kind of structure. And that is either just nominate one country to tax, which is what a lot of the European countries do with their frontier workers. They have many millions of people in Europe live on or close to the border, and they go across the border every day to go to work. So what the European countries typically do in that case, because the flows in each direction are more or less the same, they just say, we'll tax in the country of residence, we won't bother taxing in the country where the people live. It's a much simpler solution. They don't have to file tax returns in two countries. You don't have to deal with problems of mismatches of the taxes and so on. What I think would probably be better is to try and come up with some kind of joint taxing rights where the taxing rights shift over time. So you can imagine a system, for example, that if a US worker comes to Australia, the first year the US tax is 100%, Australia 0. The second year US 80%, Australia 20%. And you just sort of phase one system out and the other system in. Yes, you've got two tax returns, but it's only for a period, and you're actually trying to consciously solve the problems by not having two full taxes, only taxes which total to one instead of more than one. So if you've got 80% in one country, 20% in the other, it's only 100% overall. Whereas currently it's 200%, and then you've got to look around for relief if you're being taxed in two countries. So again, is there a moral? In the US, this first moral will never make any headway. But many other smaller countries, and that includes pretty well everyone else in the world apart from the US, increasingly looks to the international dimension when they're looking at their fringe benefits, taxing fringe benefits, because they have this problem of people moving more and more, and they don't want to make it worse when they are considering changes to their systems. The US, that message never really sort of, it may be heard in some places, but it never seems to be heard in Congress. Congress sort of has a sovereign right to tax, and they're not very interested in what other countries are doing in setting the domestic tax rules. But what the US is interested in is where the problems arise, and the US is one of the most active in this area, in actually trying to get some international convergence or treaty rules which will fix problems. And it's noticeable, as I say, if you don't recognise it, that all the pension work that the OECD did in recent years was done by the US delegate. Basically, the US was driving all of that kind of change, because the US with its citizenship taxation is the one which is having the most problems. So that there is an active involvement by the US, not in the first, but in the second kind of approach. Is a different approach needed? I think at the end of the day you are going to need a different approach. The kinds of solutions which are being come up with at the moment may work in theory, but often in practice they don't work. You still end up with more than 100% of the benefit being taxed, because it's just not possible to get the systems together sufficiently. And I've suggested one way of doing that today. But again, the broader message in the US context is that many of these US tax reform proposals that I mentioned previously in discussing domestic taxation of benefits often involve shifting away from income tax. So the President's Tax Reform Commission, it reported last year and went nowhere, but one day something will go somewhere, presumably, in the next several years. If you read through that, we're going to, the usual kind of US proposal, we're going to shift from income to some form of expenditure tax over a period of time. You read it right at the back, it's got a few pages discussion where the Treasury people say, or the members of the Commission say, oh, there are a few treaty problems with these proposals. They're essentially completely in conflict with your tax treaty. So when you see on the one hand, the US is out there actively trying to make things work in the fringe benefits area. And yet when you get to broader tax reform, it's the usual, we'll go ahead and do it, and then we'll let the rest of the world try and sort out the problems after. So I think there is a message there that the current kinds of tax reform proposals are, they may look like they're going well in Congress, but there is going to be a big international reaction to them if they ever happen, not necessarily favourable, because essentially the US will have abrogated, arguably, all of its existing tax treaties, because it's now levying tax on a non-income basis, and tax treaties essentially are for income taxes, not for other taxes. So that's all I have to say. I'm happy to take questions. They're getting late. Yeah.
If we had an excise tax on the employer, that what happens going to be pushed backwards on it. I think it would very easily. But that isn't necessarily the case. I mean, some corporate employers are pushing tax back, some are not. Those that can't, they have to eat the tax themselves. And that means that there will be legislation related to the excise tax. You can't push it back because you cannot. The corporate employers will be differently treated depending on the kind of labor market.
I think that's true, but I think it applies equally to the taxes on the employee. Employees can effectively push their taxes to the employer if the market conditions are such that they can do it. They will just bargain in net tax terms, essentially. So I agree that any tax at the corporate level will have this problem that we never know where it really ends up. It's probably true as a matter of tendency that it's harder for the employer to push the tax, the excise tax to the employee than the true employee taxes. But I think that the same issue does arise. It depends on the bargaining in the industry. And we look at chief executive salaries. What's that? The old US case where when the income tax first came in, old Holiday. And the company just paid the executive's tax. I'm calling the trust. I think the same thing happens with executives nowadays. They say, oh, I don't want to pay this tax, just pay me more and I'll have the corporation effect.
I had an issue once a number of years ago that I researched for a former employer involved in attorneys who were relocated from Cleveland to the Czech Republic. And I recall the IRS had a rule that you take your family there and you bring them back. But what made it a little bit more difficult for this family was the wife was pregnant and they wanted the kid to be born in Cleveland at University Hospital. So that meant bringing the whole family back. Does Australia have any similar kinds of rules about how often you can bring a family backwards and forwards before there's a tax treatment or a different tax treatment? Just relocation.
We'll give you a break of 50% of the fares once every 18 months. So we do have a rule on that, but it's not a complete exemption, it's only 50%. We exclude 50% of the cost, and it's only once every 18 months. So it's a typical only, rather than medical emergency kind of scenario, which is more not medical emergency but medical issue. It's mainly intended for home leave, which is a typical part of an expatriates package, that they're allowed, the company pays for them to go home sort of once every 18 months or 2 years, because of extended family and all the other reasons to go home. So yes, we do. Those kinds of homely rules are relatively common. I don't know much about the US, and what you're saying, if there wasn't then, there probably isn't now anything to cover this. But that's one of the issues about what is really a cost of employment, or what is a working condition. It seems reasonable to say you can go home, it's not really sort of fringe benefit in any more sense. Yeah.
Do you have any comments on flat income tax regime based on experience in other countries?
It depends what kind of flat tax you're talking about. If you're talking about a flat income tax, so we are talking income tax. The flat tax.
No, flat income.
The flat tax is not an income tax; it's a consumption tax. Exactly one of the ones that the taxes I was talking about. If it's a flat income tax, not many countries have them. Mainly in Eastern Europe is where you find them, and that's because of their economic scenarios, their economic situation. And I don't think they're sustainable. I think, at least in most countries I'm familiar with, the political consensus is still in favour of progressive taxation to some degree. And the flat tax is going, in most cases, just going a little bit too far, because it doesn't matter how you package it, you're going to end up shifting the tax burden from the very wealthy to the less wealthy, from the middle class to the poor to some degree. And I'm in that camp. I don't think the benefits, the claimed benefits, are anywhere near what they're said to be, and the political consensus in most countries is not there to do it. Yeah.
Does Australia attack the double taxation problem on dividends differently than we do?
We have a full imputation system, so again that's why I'm aware of this. That means we credit the tax to the shareholders. So it's not like the US proposal where the dividend was going to be exempt. We have a corporate tax rate of 30. So if a company pays a dividend of 70 and we know that corporate tax has been paid, we give a credit of 30, we gross up to 100, so you report 100 of income. You work out the tax on that and you take a tax credit for 30. So it's a full crediting of the tax. Yeah. Yeah.
I'm just wondering, could there be a rule like that an employee's place of residence be like a de facto residence, being the place in which they work, rather than the country in which they're a citizen, and would this solve any problem?
Well, typically they will become, expatriates will become a resident of the country where they're working. And because most countries will have a rule that if you're there for more than a year, and I'm talking not about short-term secondments, but expatriates tend to go for 1 to 3 years, they will normally become a resident in, say, the Australian case of Australia. They're still a citizen of the US, and it would help if the US gave up its citizenship taxation. That would help a lot of US people, and the compliance rate amongst US expatriates is notoriously very low. Many of them simply don't file their tax returns, and then when they want to come back to the US, it often is a barrier for them to come back. But I don't think, so I think the US giving up citizenship taxation would solve a lot of the problems that US people experience. The US, along with only a few other countries, uses citizenship. Everyone else uses a residence-based test. And under those rules, you get this changing of residence. So you may not be resident in more than one place, but because you're changing residence within a few years, you get the problems that I was describing. Not the US problem, but other kinds of problems. So making you a resident of the country that you've gone to won't generally be a solution to a lot of the problems. I think you've got to try, as I was suggesting earlier on, to try and slice the 100% up between the two countries rather than to say they each can tax and then try and find a foreign tax credit or some other relief mechanism. If you get straight to the taxing rights, you'll deal more directly with the problem. I don't know if that responds to your question.
I was just thinking it might be interesting to make like there is no residence anymore. There's just de facto residence, meaning wherever you work, that's where the residence is, and that's the tax system.
It's a source-only system, and a few, but not many countries operate a source-only system. So Hong Kong is still source-only, but they tax you if you work in Hong Kong. If you leave Hong Kong and earn income in the US, they don't try and tax you, even if you were still a resident in some sense of Hong Kong. The problem, and it comes back to the question over here, is that if you want to have a progressive tax system, then taxing on a source-only basis is not going to achieve the progressivity you want. If you think flat taxes are a good idea, then source-only taxation also becomes a good idea, because you're only looking at effectively one flat tax and you're not trying to achieve progressivity through the tax system. So I think in limited circumstances it can make sense, but if you believe in progressivity, then it's not going to be a feasible idea, because people can just go and work 3 months in 4 different countries and end up paying a lot less tax than if they did all the work in one country. Okay?
Yes? What is the conditions of employment is essentially a cultural, but it's going to differ from country to country. In the European Union, we have a push towards tax compensation. We're going to deal with the fact that in some places, the safety device is a condition of employment, but in other places, the safety device is a principle.
I think the answer is that you're not, and no amount of trying to solve it through treaty mechanisms are going to overcome those differences. You say that they're cultural, they have a long history in many countries, so as well as being cultural, they've also been factored into the wage negotiations. And that's why I think you've really got to think about a different approach of slicing the pie rather than giving each country rights to tax and trying to achieve a double tax relief solution. So it's an example of why I don't think the current things that are being done are likely to overcome the problems at the end of the day. Because they're administrative, they're historical, they're cultural, they're fairly deep problems that you're not going to deal with just without a rule. You need some other approach along the lines that, at least that's one possibility.
Thank you, Richard. I understand that we did have somewhat of but I guarantee you that it's there. We have a little present to you, but I can't find it. But we